Hello, good afternoon. Good afternoon, everybody, for taking time to attend today's webinar. We have I think already got a pretty good number of attendees who have logged into the system. I think we are 2 minutes away from the scheduled time of 3 o'clock. So, in the benefit of other people who are about to attend the webinar, we'll probably wait for another 2 minutes. The presenter is right there in front of us. I think we're just ready for the next 2 minutes. So we have got a chat window on the right hand side of your screen. If you have any questions, please post your questions in that panel that you see on the right hand side. I know a lot of you have already sent emails with your questions. I would request you to post these questions on the panel that is provided on the right hand side, so that we can take these questions towards the end of the webinar. If you're not able to hear, just please put up on the chat. We will see if there are any technical glitches. Let's just wait for a moment before we see more participations. Thank you. So good afternoon once again to each one of you who have taken the time this Thursday afternoon to attend this webinar. I am your host Suresh, and I'll be taking you through the webinar, probably telling you about various things that you should keep in mind to leverage the maximum out of this webinar. So before I introduce our speaker expert Suresh to you guys, let me just give you some basics on how this particular webinar we can go through it. We have got there is a panel which is on the right hand side of your screen. That panel is essentially the control panel where you can post your questions, and we'll take them up. We'll take them up at the end of the webinar as part of Q&A session. This webinar is about gratuity compliance, as you have read in the registration link as well. We will be going through Suresh, who's our expert. He'll go through on various aspects of gratuity compliances, what you should, as an organization, what you should keep in mind. For employees, what is there in gratuity, the nominations, and various gratuity services that are available, and at the end probably what ADP can do in terms of gratuity and other HR related services that we provide. A few things to keep in mind. I'll be taking up polls during the webinar. So we have designed 3 poll questions. So you don't have to do anything in that. It's just that during the webinar that Suresh will be taking now, in between we will ask you these questions, which will appear on your screen. You just have to respond to the options that you think is most suitable according to your knowledge. These questions are completely anonymous, so you don't have to worry about your email IDs being exposed and stuff like that. We are taking up these questions just to understand on how compliance services is being done in India today. So having said all this, let me just introduce you with our expert today, Mr. Suresh Nagarajan. Now, Suresh comes with over 20 years of experience in statutory compliances, and he has been handling our clients across India of varied sizes. So be it a small business with just 50 employees spread in say a couple of locations, to clients who have got their spread across the India in cities which we probably wouldn't even imagine that it exists in India, with numbers crossing more than 10,000. He's been handling such clients for ADP. Now he has. I think it's. Thank you very much, Suresh, for agreeing to do this webinar. So like we discussed, I think let's make this webinar as conversational, as much as conversation as possible. So probably in between the slides, I mean, without going the conventional way to keep the questions at the end, in between the slides, if like I have received a few questions from on email, I'll probably take up those questions in between as it comes, so that even our attendees could feel more participative about it.
Okay.
Now we hope that you are able to see the screen see the screen, so and you are able to hear us as well. So without wasting much time, Suresh, I think it's over to you.
Good afternoon to you all for taking your time to be part of this webinar. Well, this is Suresh Nagarajan from ADP. So the topic is more on the gratuity compliance, and before going into the topic, I just wanted to give an overview of what are the retirement benefits that are available, and after that I will be covering some important definitions, and next on the employee aspects with regard to the payment of gratuity and the nominations, and as an employer what are the statutory requirements, and finally what are the employer options available. So when it comes to the retirement benefits overview, there are three kinds of retirement benefits. The first one is on the provident fund, second one is on the gratuity, third is on superannuation. So on the provident fund, there are two subsects to it. Some companies, they will be having the registration with the Employees Provident Fund organization, which is under the control of Ministry of Labour, Government of India. The second segment is some companies, they will be having their own Provident Fund trust, which are duly exempted by the Provident Fund Commissioner and the Income Tax Commissioner. Then on the gratuity, again there are two options. One, as a company can pay directly to its employees the gratuity. The second option is the company, they will be having their own trust and they will have a tie-up with the insurance company. Third aspect to it is superannuation. So on the superannuation, the companies will be creating a trust and they will also have a tie-up with insurance company. So this is Provident Fund, gratuity and superannuation are the most common retirement benefits prevailing across the country. So let's move on to gratuity. The preamble, what the Act says. See, it is governed by the Payment of Gratuity Act, and the preamble, what it says is an Act provides for payment of gratuity to the employees employed in factories, mines, oil fields, plantations, ports, railway companies, shops or other establishments, and for matters connected therewith or incidental thereto. For this object, only the Gratuity Act, the Payment of Gratuity Act has been enacted. So let's move on to when the gratuity is applicable to a company. The gratuity is applicable first to every factory, mine, oil field, plantation, port and railway company, and it also applies to every shop or establishment in which 10 or more persons are employed. The third category is any other establishment in which 10 or more persons are employed and have been notified by the central government. The other establishments, when I say, it could be a banking sector, the insurance sector or NLCs, where the central government by notification in the official gazette, from that date of notification, the gratuity applies. So there are some exceptions to it. This Gratuity Act extends to the whole of India, except for plantation and ports in Jammu and Kashmir. And once the Act has become applicable, it will continue to apply even if the number of persons fall below 10. So if on a particular given date, if the number of persons has reached 10, the Gratuity Act becomes applicable to an organization, though the number has come down to 9 even on the subsequent day.
I think Suresh, I think the last slide you were talking about. You were talking about the organization. What is the gratuity applicable to organizations, right?
Yes. Yes.
So in certain cases, we see that in today's, especially the business scenario, we have seen a lot of mergers and acquisitions that's happening, right? So there are a lot of companies who, larger companies acquiring smaller companies or vice versa. So what happens in such cases to especially, to the employees, or what precautions should organizations, have it in their records before this acquisition happens? Because even we have seen in our business that when this acquisition happens, there's a lot of confusion with respect to gratuity. Anything that we can do about it?
Yes. In case of mergers and acquisitions, now it is most common. So what happens is that the company, first they have to see the agreement. There will be a agreement, merger agreement or the acquisition agreement between both the companies, wherein one of the clause will have to state that the acquiring company is, they are extending the benefits of the continuation of service to the employees to the acquiring company, and they have to do the valuation for those employees who are going to get transferred to the acquiring company, and the liability has to be transferred. So in that way, the continuation of service for those employees will be there, and when the employees leaves the company, they will be getting the gratuity for the services rendered right from the previous company to the acquiring company.
Okay, thank you, Suresh. I think it is the right time for us to even take our first poll question, where basically we will be checking on, whether this gratuity services are being how is today organization really managing their trust,
Okay.
right? So
Right.
so let me just launch a poll question. To all the attendees, for a moment, for a minute or so, you will see a poll question on your screen. So you just have to look at the options and submit your responses. So the poll question. So so the poll question that we are asking today is, do you manage separate trust for retirement service? Now, retirement service is something which Suresh just spoke about, which is your gratuity, provident fund, superannuation. How is it managed today? Are you managing it in-house, using an in-house trust, or have you outsourced it to a vendor? Or you don't belong to this department where you don't have really the idea about it? You've got 1 minute to answer. So that's a very, very healthy poll that we are seeing here, Suresh.
Okay.
Almost 60% of people have voted so far.
Okay.
We really expect more participation from all of you attendees, and I think so Suresh, while they answer this question, based on your experience, what do you think would be who will win the maximum vote? Which out of these three options?
I would say we have outsourced to a vendor.
Okay. So you think most of the people outsource to a vendor?
To a vendor.
Okay. Okay. So I think 30 more seconds, and then we'll close the poll here. Okay. So I'll close the poll question here now. So we have got a very I think you won your guess. So we have got 80% people who have answered the poll question, and out of that, around 40% of people have said that they have outsourced to vendor. Rest of them, I think around 30% is they've got in-house trust,
Okay.
and around 25% of people they don't have any idea about it.
Okay.
Over to you, Suresh.
Okay. Thanks, Suresh. Next, I'm going to talk about, from the employee's perspective, what does continuous service means. So, continuous service, as defined in the Act, means an uninterrupted service, including service which may be interrupted on account of sickness, accident, leave, absence without leave, layoff, strike, lockout, cessation of work not due to any fault of the employee. An employee shall be deemed to be in continuous service for the period of 1 year if the employee has worked for not less than 190 days. In the case of an employee employed below the ground in a mine or in an establishment which works for less than 6 days in a week. In any other case, it is 240 days. Same way, for consideration of continuous service for the period of 6 months, the employee has worked for not less than 95 days. In the case of an employee employed below the ground in a mine or in an establishment which works for less than 6 days in a week, and 120 days in any other case.
Yeah. So I think this is Suresh. I had few questions from some of our attendees on my email, and I think I've seen it in some forums as well, Suresh.
Okay.
So one of the confusion is, though we say it as 5 years is something which is largely accepted sort of term period, right? But then there is some confusion around 4 years and 240 days number. How do we, can you please provide some clarity to our attendees?
Yes, Suresh. So when the Act has been enacted in 1972, it was categorically told that 5 years. So, but if you look into the Act, this section 2A clause of the Act, where if an employee has completed 4 years and in between if he has resigned after completion of, let's say, 10 months, so for the purpose of consideration of a year, we will have to go back to this class of continuous service, which talks about very clearly saying that you will have to consider 240 days if an employee has worked in that 5th year. So 4 years plus 240 days will be construed as 5 years. And also, so which that is a Madras High Court judgment to this, which was decided on 12th June 1996.
Okay.
And the judge also has clearly told that the claim of that gratuity is tenable, citing this continuous service.
Okay. So I think this Madras High Court, the judgment is also applicable for across the country, if I'm not wrong.
Yes.
Okay. Thank you, Suresh. You may please proceed.
So next, let's see, payment of gratuity to an employee. when as an organization we can pay the gratuity to an employee. Gratuity is payable upon termination of employment after rendering a continuous service of 5 years on superannuation or retirement age, retirement or resignation, death or disablement. In the case of death or disablement, 5 years of service is not required. In the case of death, gratuity shall be payable to the nominee if no nomination has been made to the here or heres. If the nominee or here is a minor, it shall be deposited with the controlling authority. So the controlling authority shall invest the money in public financial institutions or banks, and the minor, when he or she attains major, the gratuity amount will be settled. The computation for gratuity is 15 days lost drawn wages shall be paid for every completed year of service or part thereof in excess of 6 months. Here, for a month, the days to be construed as 26 days, leaving Sundays apart. In case of a seasonal establishment, 7 days wages shall be paid for every season. In case of a piece-rated payment setup, average wage for the preceding 3 months shall be considered. There is an important note to it. The maximum gratuity payable allowed as per the Act is 10 lakhs. Having said that, there is another important note. Nothing in the Act prevents better terms of gratuity under any award or agreement.
Yeah, so I think there was another question, Suresh, and I was just browsing through several questions as well. Probably it would be a good idea. Maybe we can just rephrase on how to really calculate gratuity, because I was just going through questions, and I can see that around 5 to 6 attendees have asked this question on how do we really calculate it. Okay, mathematically, if we can just explain it to attendees.
Okay. So let's say if an employee's salary is 50,000. So here when I say salary, it means basic and DA, whichever company provides DA. So basic plus DA will be considered for the purpose of calculation. So when an employee is drawing salary of 50,000, which is last month's salary, so 50,000 multiplied by 15 days salary. So multiplied by 15 divided by 26. 26 is the dividing factor into completed years of service. Suppose if an employee has put in 5 years and 8 months, then completed year of service in this case will be 6 years.
Right, right. So I think that that clears the question. I am seeing a lot of people have asked that question. So another doubt I think that is part of this question that we are getting is, should gratuity be really part of the CTC, the cost to the company? Should it be should the employer put it in the CTC of, say, the offer letter of an employee? Should it be part of that? What is the best practice?
The best practice is CTC from the employee CTC, gratuity should not be a part of employee CTC. The reason why is, in case if the employee has not rendered the eligible period of service, which is 5 years, and if he raises any dispute to the labor court with the CTC letter in hand saying that though I am not eligible for gratuity, the company has set aside this amount, so I require this amount. They will raise the dispute. At that time, the labor authorities will be in favor of the employee unless and until the company has sufficient justification to prove the stand that why they have accommodated this cost as a part of the CTC. So that is option to it. In such a case, what they can do, if they are going for the option, what I said is, if they have a gratuity trust, so the company on a yearly basis, they will park the funds to the gratuity trust account by way of actuarial valuation, and that fund will not be utilized for the business needs. That fund will only be utilized for the employee benefits. So if the company is adopting this option, they can prove to the labor authority in case of any dispute.
Sure. Thank you, Suresh. I can see a lot of questions coming on the same part with the same response that you have given. Probably the amount of questions that I'm seeing right now, I think it would be a good idea if we can, probably skim through these slides a little faster so that we can take up these questions. I also request our attendees to be there with us till the end of the webinar, because the questions that different attendees are raising, I think a lot of clarification can be, a lot of things can be clarified by just listening to answers of these questions. Over to you, Suresh.
So there is another important topic on the nominations part. So nominations. Employee who has completed 1 year of service should make nomination in favor of one or more members of his family. So 2 copies of nomination are required to be filled by the employee. One will be returned to the employee, and employee has to acknowledge that he has received the nomination, and the other copy employer should keep in their safe custody. So in an event without any family members, nomination may be made in favor of any person of concerned employee's interest. But immediately, if an employee gets a family, the nomination must be changed. In this case, the older nomination will become invalid. Modification of nomination can be made at any time by the employee. There is also the effect of nominee predeceases the employee. In that case also, the nomination has to be changed. So we have seen family in the nomination slide. So what does family mean? It's simple for male employees, that is himself, wife, children, dependent parents of wife and son. Similarly for female employees as well. These are the statutory requirements on the part of the employer one should have in place. So Form A, it's a notice of opening. Within 30 days of applicability, the act becomes applicable to an establishment. Form B, which is notice of change of name, change of address, change of ownership, etc. Form C, notice of closure. There is a timeline. Form F is the nomination form. Form G is the fresh nomination. When the employee is acquiring a family, he has to fill Form G and not Form F. Form H is modification of nomination. Form I, J, K, these are application by employee, nominee or legal heir at the time of leaving the service. Form L is notice for payment of gratuity to an employee. Form M, notice rejecting claim, and Form U is abstract. There are options available to an employer. This is the most important part. The option 1 is pay when employee leaves. So what happens is, this is a non-funded provision in the balance sheet item. It leads to accumulation of liability for the company on the balance sheet. Company does not get any tax benefit on provisioning, only on payment they get the tax benefit. Option 2 is approved gratuity trust. So they need to set up an IT approved irrevocable trust. Company gets tax benefit on contributions payable to trust. Past service liability can be funded over a period of 5 years as per the income tax guideline. Out of this approved gratuity trust, there are two parts to it: self-managed trust and insurance company. Self-managed trust, where you have to manage the investments and you will have limited exposure to equity, can lead to suboptimal performance. Insurance company, they come with several attractive options to manage the liability, being their core competency, and company can benefit from the expertise in fund management.
So before I think yeah, that kind of brings us to the end of the gratuity session at least. Now before I go to the second session on what we can really do with ADP, attendees, it's the time for second question. So if you can just please concentrate on your screen, we are asking the second question on compliance management. So we have so there is compliance management which is available today as a service. What if there is a compliance management on the cloud? Will you? So the question, I'm just about to launch the poll. So if you look at the question, the question is available, and the question is, would you be interested in a cloud solution to manage your compliance-related documents? Now, if you see today, you're maintaining these documents as a physical copy in your offices, and which I'm sure Suresh would agree that how difficult it is to manage all the papers. So what if this solution is available on the cloud? Now this is something which ADP is working at, and we are essentially seeing the response from you guys who are on day-to-day basis working with these documents. If anything like this would really make your life a little more simple. So you have just two options. Yes, that would be interesting, and if you think that you're happy today with whatever it is, you can just select the second option. Let's give for another 10 seconds. I think I love these attendees today, Suresh. We've got really good participation, and I see that 76% people have already voted. I would definitely want to surpass our previous poll question, which was 80. So yeah, so let us give another 5 seconds more. Okay, so we have got around 81% people.
Excellent.
Out of that, 61% of them think that it would be interesting if there is a cloud-based compliance management system. Now, thank you very much, Suresh, for giving us sharing your knowledge on gratuity. I'm sure there's a lot of questions waiting for you. Just before we get into the Q&A round, let me just probably give you an overview of what we really do at ADP. Now, for those who don't know about ADP, I know a lot of our clients are also attending this session. For those who don't know about ADP, ADP is it is a global leader in HCM, human capital management, and payroll solution. In India, we've been there for quite some time now, and we have got clients spread across the country and across different segments that we operate in. That is a small business, medium-sized business of 100 to 1,000 and 1,000 above business as well. So we have got our payroll solution, which is on cloud. We have got time and attendance on the cloud. Payroll, we have got our services as well, which is managed services, where you can outsource your entire division to ADP, and that's been our major business so far. But we are seeing a very strong, strong traction towards a cloud-based payroll solution as well. Now, other modules, if you look at the circle, the other modules that we have is statutory compliances. Some of that module, which Suresh has already spoken, HRIS, which is your human resource information system, where you can right from the onboarding of your employees to their payroll, their time and attendance data, their reporting which is required, employee self-service. We have got a dedicated team over here for our clients who can answer to clients' employees' queries as well. So if I have to take that statutory compliance module separately, then we provide services in payroll compliances, which is your PSI, professional taxes, labor welfare fund. Thank you, Suresh. So all of that is provided in the payroll compliances. Shops and establishment services is something we provide. Factory compliances, CLRA, and retirement and trust management services. Now, this is something which Suresh has spoken in this particular webinar. So under the gratuity service offering, if you look at it, we are doing gratuity trust formation, which is essentially creation of gratuity trust. So I know in first poll question, a lot of you have answered that you have got around 30% of our attendees have got in-house gratuity trust, rest of the 25-30% have outsourced it. So we do creation of gratuity trust for our clients. We tie up with insurance companies and support in documentation process, filing of application to Commissioner of Income Tax for recognition, monthly management. There's a lot of transactional activities which are required, compliance adherence, investment compliances. This is in case of managed trust. You need to have compliances for the investment as well. Books of accounts, very important stuff, which is again monthly recurring sort of activity which we manage. On a yearly basis, we do finalization of accounts, compliance adherence again on the yearly audit basis, ad hoc requests. So, there are a lot of requests which comes from our clients which are on very ad hoc basis. So that would be amendments in statute, amendments in trust rules or company name change, trustee change, etc. So before we start our next question, so let me, or rather the next is on the Q&A round. So I think we've had a pretty good number of questions that's on our way.
Okay.
So without wasting much of time, let me just go through the Q&A question. So Suresh, your first question is, what is the mandate to have in-house trust for retirement benefits?
When you say retirement benefits, as I said, the retirement benefits are provident fund, gratuity, and superannuation. So in order to if company should have an in-house provident fund trust, now the commissioner is giving exemption provided if there are 3 conditions. One is the minimum number of employees. Earlier it was 200. Now if you have at least 1,000 employees strength, that is one. Second is whatever the benefits you are providing to the employees, that has to be at par or more than the benefits provided in the Act. Third is the company has to be a profit making for the 3 years. So this is on the part of the provident fund. For gratuity, there is no minimum number of employee strength. The Act says that if the employee count is 10, the company can go in for the gratuity.
Okay. Okay, thank you, Suresh. The question, if this next question is, if the acquired company has not maintained gratuity in their company, then what should be the acquiring company consider?
The acquiring company has to consider the past service put in by the employees in the acquired company, and they have to estimate the liability through actuarial valuation. There are panel of certified actuaries through whom they can get it done. That determines the liability of the acquired company to be transferred to the acquiring company, so that the services of the employee will be continued for payment of gratuity.
Okay, so we have another question on. So I think it's about the offer letter, right? What information should be incorporated in the offer letter regarding payment of gratuity?
As I said, it is ideal not to incorporate in the employee offer letter the gratuity clause if the company doesn't have any separate trust created for the gratuity.
Okay, I hope that answers this question. So the question is temporary period should be also should temporary period be considered for calculation of gratuity?
The day the employee comes on the rolls of the company, from that day the service period counts.
Okay. Okay. So so there's one person who has asked. So her organization is just 4 years old in India. They have not started gratuity services yet. So if they start, say for example, next year, then will those years be in account from employees' actually date of joining?
Yes, that will be accounted from the actual date of joining.
Okay. Can this be, another question is, can this be mentioned as a benefit in appointment letter, benefit document along with appointment letter basically? If yes, what way it can be mentioned?
So, if the company is mentioning in the appointment letter as a benefit document, then it should be clearly stated that this benefit does not part of your CTC. This is over and above the employee's CTC the company is offering.
Okay. The next question is, what possible conditions can be considered in case of layoff, strike, cessation of work not due to employee fault? I think you covered that in one of your slides.
Yes.
Yeah, you can answer that.
So this is most common in case of a factory setup where there will be a strike or a layoff for some period. So those situations can be considered.
Okay. Should maternity leave be considered under this act?
Yes, maternity leave is considered under this act.
Okay. Can a company decide to have 3 years or less as minimum eligibility for payment of gratuity instead of 5 years to attract new joiners? This is a very interesting question.
Yeah, it's a very interesting question.
Yeah.
It is the act nowhere says that the company has to pay gratuity for a minimum period of 5 years. If the company decides to give for 3 years, it cannot be termed as a gratuity payment. It can be in the form of an ex gratia, which is subject to tax.
I see. Okay. Okay. But then there is no restriction as such, right?
There is no restriction.
Yes. So if you want to be good, you can do good.
Yes, you can do good.
Cool. So The next question is, I think it was about the 240 working days. So is it 240 working days as per section 2A?
It is 240 days in that given year. It is not working days.
So I think based on the conversation we had on High Court of Tamil Nadu, right, Madras High Court. So there's one person who was asked if that is applicable only for Tamil Nadu or other states as well. So I think it is applicable for other states as well. Right? One question is, what is the difference between retirement and superannuation?
Superannuation is, the company will be having a superannuated age which is 58 years. Some companies will they can define the retirement age which will be below the superannuation age. It can be 55 years or 50 years.
Okay. So I think before before we take up other questions, I'm waiting to waiting to ask the next poll question. Attendees, I would really request you to answer this question, and then we can take up the rest of the question with whatever time we have got in our hand. So the question comes on your screen. So what do you think about this webinar? So if you think that we should continue the similar format, you've learned something new, please click on the first option. If you would like somebody from ADP to contact you for the services that I mentioned that we provide, whether it be payroll services or on cloud services, or services regarding retirement services like what Suresh has mentioned, you can contact second option and we'll send you an email. We don't know your email ID, but then we'll try to send an option to all our attendees to on how we can take the discussion. And a third option, we take good and bad feedback at the same with same enthusiasm. So if you think that you haven't learned anything new, please select that option if that is the truth, because we would definitely want to improve for the next webinar. So we'll give another 10 seconds, 10-15 seconds for people to respond to the. All right, so Suresh, I think 84-85% of people have given you thumbs up.
Okay.
So
thanks to you all.
So I think we've got to. This is one of the response where it kind of establishes the fact that there's always room for knowledge sharing.
Yes.
So for the rest of the people who have voted for ADP to contact them, we'll definitely arrange some sort of communication to them. And rest of the percentage, which we have, around 5% of people think that this webinar was very helpful. We really apologize for this, and we'll definitely ensure that we'll work towards to improve the content of the webinar. And if there is anything with respect to the technology, or you're not able to hear us properly, or if it was something regarding the conversation style, please write an email to us, and we'll definitely improve on that. Thank you for taking part in our poll. I'll close this poll now, and we'll continue with our questions. So we have got who's the controlling authority here, Suresh?
The controlling authority for the payment of gratuity is Labour Commissioner Central.
So I think some of the people, for the benefit of larger audience, some of them had have doubts in terms of the calculation. So one question which I saw in between it was, why is it 26 and why not 30? I remember I asked you that question, so maybe you can give that. And the other question was, shouldn't it be just basic salary, or should it be like the entire salary?
To answer your first question, if the dividing factor, if we are taking 26 into consideration, it is beneficial to employees. The act always enacted for the benefit of the employees, and and secondly, as I said, Sundays is a weekly off, any company for that matter. So leaving Sundays apart, the government has framed that 26 days has to be taken into consideration for employees' benefit.
Okay.
Second.
Yeah. So the second question was with regards to the basic salary. Should it be basic salary or should it be?
It should be basic salary plus DA wherever applicable.
So basic salary plus DA of last drawn.
Of last drawn.
Right. Okay.
Suppose if an employee has resigned in the month of August, the company has to consider July month.
Okay. Okay. Great. There was a question again on what is a seasonal establishment. What is a seasonal establishment?
Seasonal establishments, an establishment which works only for that particular season. So probably it could be a winter season where the fruit manufacturing companies, fruit selling companies, they work on a particular season.
Right.
So in such a case, where the employee, for the payment of gratuity, they have to consider 7 days.
Great. I think that clarifies. Well, this question, I remember asking you this question as well. What is piece rated payment? I think you responded saying that if in certain organization or certain sector, the payment is done by the number of products.
Like number of pieces produced.
Number of pieces they produce, right?
Yeah.
So I think that answers the question.
Yes, that answers the question.
Yeah. Do you have
based on the number of pieces produced,
right?
The employer pays wages to an employee. So that wages has to be taken into consideration.
Okay. So there's another question on the qualifying period of days for the 6th year of the service. Will it be 120 of service, 120 days of service after the 5th year, or 240 days of service after the 5th year to be eligible for 6 years of service for gratuity as per that? I think it is beyond 120. It is. You were saying about 6 months.
Yeah, it is beyond 120.
Yeah.
So above 5 years, 6 months or more are to be taken as 1 year. For determining 6 months, we have to consider 120.
So can an employer refuse to pay gratuity to an employee due to financial loss to the employer?
Yes, there is a forfeiture. Employee can forfeit the gratuity to the extent of the loss, financial loss caused by the employee.
Okay. So I think we'll take questions for 5 more minutes. Limitation of rupees 10 lakh, is it also, so 10 lakh, what happens beyond that? And also the question is it applicable for private sector?
So as I stated earlier in my earlier slide, if the Act provides the maximum ceiling of 10 lakhs, even that is applicable for private sector. However, having said that, if any company wants to pay more than 10 lakhs, they can do so, because there is an important note saying that nothing prevents in the Act provides for better payment of gratuity.
Okay, so I think that answers several questions where people have asked, the person retires, say, after 30 years, so the gratuity will definitely go beyond 10 lakhs. So your response to them would be like, there's no cap.
That is, if there is no cap, they can provide.
Yeah.
But anything beyond 10 lakhs, it is subject to tax.
Subject to tax, exactly. There is another question. I think this is again very very common scenario in today's organization, where employees take sabbaticals, right? Long leaves, if I may use the word. So if an employee is on sabbatical leave for 6 months or 1 year and he has joined back, will that be treated as continuous service?
The sabbatical leave is the employee willingness.
Okay.
It is as stated in my slide. It clearly states that if any leave, this is not due to the fault of the employee, then that can be considered. Since this is employee willingness, it need not be considered for determination of service.
Okay. Okay. I think this is another which we answered in your mergers and acquisition thing. So gratuity payment in case of employee has worked for more than 5 years with the same employer but in different establishment. So it can be a group of companies, I think.
Yes.
So how do we handle that?
So in that case, if an employee leaves that organization, they can consider the service right from the date of joining of the previous establishment to the date of service of the current establishment. But also they should ensure that whatever the liability on account of past service has been transferred or made necessary provision in the books of accounts.
So I think there's some speculation also which is going around. I wouldn't want you to comment on that, but if there is any law which is already passed, maybe you can prove it. Maybe you can just tell to our attendees. So what people are saying is we've heard that government is thinking about making gratuity portable from one company to another. Is that true? Okay, so yeah, so I think you can so you can check with your facts.
Yes,
you can check with your facts
and revert back to.
Yeah, sure, I can do that. Yeah. So let me just yeah. Can gratuity be processed without Form I?
Yes, gratuity can be processed without Form I. Having said that, Form I is one of the statutory requirement, but an employer should not stop the gratuity payment if an employee fails to produce Form I.
Okay, thank you, Suresh. So we will just take up another 2-3 questions.
Okay.
So there's one question. We are paying gratuity through LIC. We make payment of premium to all employees from day one. In that case, do we consider including gratuity premium paid to LIC as part of CTC?
Yes. Any company which is having a group gratuity scheme with LIC or any other insurance company, they can accommodate this gratuity premium payment as a part of the CTC.
Okay. So there was one question which I'm unable to find now, but the question was, I think, the person is from school, and he wanted to know that if this gratuity set of schemes is also applicable for educational institutes.
Yes, it also applies to educational institutions.
Okay. So basically, barring you mentioned about exceptions in Jammu and Kashmir, barring the plantation and ports, everybody else with more than 10 employees are part of this scheme, right? And they have to abide by this scheme. So there are some questions about how ADP is doing it in terms of gratuity. I think because in the interest of this being a knowledge session, we will definitely revert back to the people who are asking about ADP in a separate email. email, I mean, let's not make it as a sales pitch sort of thing, right? So, so is in case of CTC mentioned in offer appointment letter, is the company bound to publish the details on utilization of funds to the employees in timely manner?
Yes, sir.
So basically what the gentleman is asking is when you mention CTC in an offer letter, right? So if the company is bound to publish the details on utilization of funds?
Not necessary.
Okay. So if an organization is say for example terminating an employee on gross misconduct, is it necessary to pay gratuity as part of?
No, not required.
Okay. So I think there's another question which I think it is after our poll question. So why cloud-based system is preferred? I think one of the major reason is the simplicity it provides in terms of handling the documents.
Handling the documents, and as a company, they can able to see the real-time compliance status.
Hmm. Yeah. There was another question on what is CLRA?
CLRA is Contract Labor Regulation Act, Regulation and Abolition Act.
Okay. Okay. So can you probably for the interest of our listeners, if you can just explain a little more on that?
See, the Contract Labor Regulation and Abolition Act provides that any company which is engaging contract employees through a contractor, and if the number of employees are more than 20 in number, then they have to be bound by the regulations of the CLRA, where the company becomes the principal employer, and if any contractor fails to discharge the duties, like any delay in payment of wages or delay in payment of statutory compliance, the principal employer will be held accountable for that.
Okay. So there is another question. So gratuity has to be paid by employer, right? So why the trust has to be formed or fund has to be managed in insurance vendor? Well, I think that is the clarity which a lot of people want to know.
Yeah, that's what I have also told. Company is paying the gratuity when the employee is having 500 plus in numbers. When they are making the payment, only during the time of payment they get the tax benefit. This becomes a non-funded provision in the balance sheet item, which accounting standards 15 discourages that.
Okay. Okay. So there was, I think, a few more questions on. So I'll just combine these questions. So basically, to understand, I think you must have seen in your experience as well. People are asking that, what is the real difference between, you are managing your retirement services, your compliance management services in-house versus, outsourcing it to somebody like ADP, probably who has spread across the country, across different states, and they have people who can go and talk to the government establishments. What is the difference? What is the difference in the experience?
The difference is the ADP. ADP consists of a panel of experts who handles these compliance activities. They are having a reach or connect to the government officials, and from the company point of view, that is not their core business. So that is why they are interested in outsourcing these activities to a service provider.
Yeah. So I think another, I remember talking to a few of our clients, and one of the other core reasons was, like you said, it is not their core business, and these acts or laws, like not just the gratuity, but if you look at the payroll compliances or the
Sure.
laws, SND or factory compliance, all of these laws, they are different for each state.
Right.
Right. And the filing of the filing of these compliances, the dates are different.
Dates
right?
are different, and the
forms are different,
and the governing bodies
are different. So if an organization whose core objective is not to, in the compliances and payroll division, then it becomes very difficult to track all these changes, right? And it kind of takes away the attention from their core business than running behind to running behind all of these establishments.
Yes, and any company for that matter, if the business is important for the company, but parallelly the compliance also is important.
Yeah.
So without 100% compliance, they cannot able to focus on the business as well.
Yeah, that's true. So I think with that we come to the end of this webinar. There were like more than 300 questions. I know we have not taken most of them, but what I think we have done is we've combined a lot of questions into one or two broad questions, and we try to answer it. But for the questions that have gone unanswered, I'm really sorry for extending the time. So we'll try to answer these questions on email. But in case there are some urgent questions, you also have our email IDs. You can ask your questions to us. Right. So thank you very much, Suresh, for taking your time and sharing your experience and knowledge with our audience. And to you audience especially, I think it was a great session. Our polls had more than 80% of response rate. I think it was the questions are still coming, and I really feel sorry for closing up this webinar, because the scheduled we have already surpassed 15 minutes over the scheduled time. I'll make sure that you receive the video telecast, video recording of this webinar by next week. As soon as this webinar ends, we'll try to process this video and upload it on our YouTube channel. We'll send to all of you an email with the YouTube link, where you can revisit revisit the session and then hear about the webinar more deeper. We also have, I know a lot of HRs are getting onto Twitter for various chat and discussions. So we are on Twitter. Please go to Twitter and hit that follow button on ADPs_in. We update our various, we do our various updates on our Twitter channel. It's a very new platform that we have subscribed to. It's just been a few weeks ago that we created Twitter profile for ADP India. So help us be more participative in the Twitter on the Twitter, and we look forward to the next webinar, your participation in the next webinar, which will happen next month around same time, and we are trying to take in some topics around payroll. But if in case you have any topic in mind, you can send it across to us. We'll see if there is a huge demand on that, we'll take the webinar on that topic. So with that, thank you very much, Suresh, and you have a very good evening ahead. To all the audience, you have a very good evening ahead, and we expect you to ask more questions if you have any. We'll try to answer them. Thank you very much.
Thank you all for your valuable time in attending to this session.